time to time provided for increasing association of its people with the administration of the state with the object of realizing the goal of full responsible government at as early a stage as possible. And he added that he had noted with gratification and pride the progress made so far and the legitimate desire of his people for the immediate establishment of fully democratic constitution based on adult franchise with a hereditary ruler from his dynasty as the constitutional head of an executive responsible to the legislature. Remember, by this time, the 1957 Constitution of Jammu and Kashmir had come into play. So the argument was, how do you expect this Maharaja to continue with the power when we have a constitution of our own? So therefore, this power and this proclamation issued by him is bad. It's in that context that the judgment is rendered. It appears that before this proclamation was issued, the Maharaja had already appointed Sheikh Muhammad Abdullah, who was then the popular leader of the people, at the head of the emergency administration. By the proclamation, the Maharaja replaced the emergency administration by a popular interim government and provided for its powers, duties, and functions pending the formation of fully democratic government. Clause 1 of proclamation provides for the composition of the ministry. You Lordships may leave that, Malas. I straight away come to para 23. PDF page 14, paragraph 23. This was the contention of in the suit, which ultimately came to the Supreme Court. The validity of the act is impeached mainly on the ground that Yuvraj Karan Singh had no authority to promulgate the said act. It is this argument which has been urged before us by Mr. Chatterjee in different and alternative forms needs careful examination. The first attack against the competence of Yuvraj proceeds on the assumption that at the time when the Maharaja Hari Singh conveyed his powers to Yuvraj by his proclamation in 49, he was himself no more than a constitutional monarch, and as such he could convey to Yuvraj Karan Singh no higher powers. Let us first deal with this argument. Prior to the passing of the Independence Act, the sovereignty of Maharaja Hari Singh over the state of Jammu and Kashmir was subject to such limitations as were constitutionally imposed on it by the paramountcy of the British Crown and by the treaties and agreements entered into between the rulers of the state and the British government. It cannot be disputed that so far as the internal administration and governance of the state were concerned, Maharaja Hari Singh, like his predecessors, was an absolute monarch, and that all the powers, legislative, executive, and judicial, in relation to his state and its governance inherently vested, and that all the powers, the position has been emphatically brought out by Section 3 of the regulation, and its governance though by this regulation, Hari Singh gave effect to his intention to provide the association of his subjects in the matter of legislation and administration. By Section 3, he fully preserved to himself all the existing legislative, executive, and judicial powers. Section 3 not only preserves the said powers, but expressly provides that nothing contained in the regulation shall affect or deem to have affected the right and prerogative of His Highness. But as your Lordships may leave this now, and then it is, however, urged that the constitutional position substantially altered by the subsequent Constitutional Act of 1996. We are unable to accept this argument. 4 and 5 of this Act in terms continue to preserve the powers, legislative, executive, and judicial, as well as the right and prerogative of His Highness, just as Section 3 of the regulation of 1991. So, but they uphold it, even though there is a Praja Sabha at that time. They said the Maharaja's powers are intact. But of course, the situation is completely changed now. You no longer have the Maharaja. So now all the powers are with the legislature. So in a sense, this is a pre-1957 situation, which preserved the powers of the Maharaja till the Maharaja had to give up his powers. So let's not. That's all right. And let's quickly now. Now, kindly see 34. Just 1 minute. 34, PDF 19. Having provided for the legislative power of Parliament and for the application of the articles of the Constitution, Article 370, Clause 2 prescribes that if the concurrence of the government of the state required by the relevant sub-clauses of Clause 1 has been given before the Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly for such decision as it may take thereon. This is what I was saying in the morning as well. Even in respect of laws passed, the concurrence of the Constituent Assembly was necessary. This clause shows that the Constitution makers attach great importance to the final decision of the Constituent Assembly. And the continuance of the exercise of powers conferred on Parliament and the President by the relevant temporary provisions of 371 is made conditional on the final approval by the said Constituent Assembly in such matters. Clause 3 authorizes the President to declare by public notification that this article shall cease to be operative or shall be operative only with specified exceptions and modifications. But this power can be exercised by the President only if the Constituent Assembly of the state makes recommendation in that behalf. This is also a Constitutional Bench judgment.
Well, which para is this, Mr. Sibil?
This is para 35.
What's the year of the judgment?
1959. Sorry, I'm sorry. Give the year, please. 59. After the Constitution of Jammu and Kashmir comes. And this is a Constitutional Bench judgment. Clause 3 authorizes the President to declare by public notification that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by the President only if the Constituent Assembly of the state makes recommendations on that behalf. Thus, the proviso to Clause 3 also emphasizes the importance which was attached to the final decision of the Constituent Assembly of Kashmir in regard to the relevant matters covered by 370. This is how this court also understood it. The appellant contends that the scheme of this article clearly shows that the person who would be recognized by the President as the Maharaja of Jammu and Kashmir was treated as no more than a constitutional ruler of the state. In regard to matters covered by this article, he could not function or decide by himself and his own discretion. The constitution contemplated by this article had to be with the Maharaja acting on the advice of the Council of Ministers, and the concurrence prescribed by it had to be similarly obtained and given. And that brings out the limitations of the powers of the Maharaja. It is also urged that the final decision in these matters had been deliberately left to the Constituent Assembly, which was going to be convened for the framing of the Constitution of the state, and that again emphasizes the limitations imposed. This argument assumes that under Article 370, sub-Article 1, it is the person recognized by the President as the Maharaja who has to act on the advice of the Council of Ministers in relation to matters covered by 370. But it is possible to take the view that the said clause really indicates that in recognizing any person as the Maharaja of the state, the President has to act on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation dated 5th March 1948. If that be the true construction of the explanation, then the argument that before the Maharaja is consulted or its concurrence is obtained, he must act on the advice of the ministers would not be valid. We would, however, like to deal with the argument even on the assumption that the construction put by the appellant, the explanation is right, and then they deal with it. On the said construction, the question which falls for consideration is, do the provisions of 370 affect the plenary powers of the Maharaja in the matter of governance of the state? The effect of the application of the present article has to be judged in the light of its objects and its terms considered in the context of special features of the constitutional relationship between state and India. The constitution makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself. Mark these words, please. That it is the main basis and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to its subject matter. It would not be permissible or legitimate to hold that by implication the article sought to impose limitations on the plenary legislative powers of the Maharaja. These powers had been recognized and specifically provided by the Constitution Act of the state itself, and it was not and could not have been within the contemplation or competence of the constitutional makers to impinge even indirectly on the said powers. It would be recalled that the instrument of accession, those powers have been expressly recognized and preserved, and neither the subsequent proclamation issued by Ruvraj, adopting as far as it was applicable the proposed Constitution of India, nor the constitution order subsequently issued by the President purported to impose any limitations on the said legislative power. What form of government the state would adopt was a matter which had to be and naturally was left to be decided by the Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by the instrument of accession. It would therefore be unreasonable to assume that the application of 370 could have affected or was intended to affect the plenary power. So, this is how this court, constitution bench of this court, interpreted 370. And then, they refer to 245, 254 and say that those provisions were not applicable anyway. Then it says, it is difficult to see how this article supports the appellant's contention. In fact, it is not easy to appreciate what the application of this article to the state meant. As we have already pointed out, the application of the specified articles to the state was not intended to affect and constitutionally could not have affected the form of government prevailing in the state and the plenary legislative powers of the Maharaja. And that was all this was, the rest is. So that gives you an indication as to how a constitutional bench of this court looked at 370. And in the context of the Constituent Assembly, leaving it to the Constituent Assembly to decide upon the relationship between the state and the Union of India at that point in time. The next is Lakhanpal Sama. This is not necessary. This is the second Lakhanpal, where the detention, again he challenges detention. And the law on detention was extended to 15 years. And therefore that detention was also upheld. So we'll skip the second Lakhanpal. Yes. Yes, sorry. No, it's not detention. It's the second one, Sampath Prakash Das detention. This is a case, where members were sent at the instance of the legislature to Parliament on a recommendation of the legislature, which was a special provision in 81 of the Jammu Kashmir Constitution, and said that, look, there can be no direct election. It has to be at the three of them. A few of them have to be at the instance of the legislature, on the recommendation of the legislature. Really speaking, the core issue is it's all right. Let's not go into it. Sampath Kumar was this. This was a case of detention, again a case of detention. And kindly come to paragraph. And the law of detention was extended from time to time till it was for 15 years at a stretch. And that detention order was challenged. But see that PDF 29, paragraph starting the first argument. Yes. Continuation of paragraph 4 at PDF 28. He challenged his detention order, and the first argument he made was the following. PDF 29, what's the time? Finish. My lord has that?
They say that the power of the president to make modifications is of the widest amplitude.
That's Lakhanpal.
That's Lakhanpal.
Yeah. Lakhanpal 2, right?
And that the power to make a modification includes the power to make an amendment to the Constitution.
Yes, yes. And that is also with the concurrence, Malaj. It's not without concurrence. That's not without concurrence, Malaj.
Yes, that's right. That concurrence was not an issue there.
Just saying, Malaj. It's not in the absence of concurrence. It's
Obviously.
But 368 is therefore not really applicable as well. Because you're not amending the main constitution.
That's right. That's right. Absolutely right. Doubtable. Doubtable. Now, Malaj, now in this Sampath Prakash, PDF Malaj 29, and I'm inviting my lords to paragraph 4 at PDF 28 at 29, the PDF 29, the first argument. The first argument, no, my lord has that. The first argument was that this article contained temporary provisions which ceased to be effected after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir had completed its task by framing the Constitution of that state. Reliance was placed on the historical background in which Article 370 was included in the Constitution to urge that the powers under the article were intended to be conferred only for the limited period under the Constitution of the state was framed, and that the President could not resort to them after the Constituent Assembly had completed its work by framing the Constitution of the state. The background of the legislative history to which reference was made was brought to our notice by learned counsel by drawing attention to the speech of Gopalaswamy Iyengar, which your lordship read, when he moved in the Constituent Assembly clause 306A of the bill, which now corresponds to 370. It was stated by him, the condition that leave that out, Mullah. Then, further down, Mullah, after those 7 items, learned counsel urged that in this background, 370 of the Constitution could only have been intended to remain effective until the Constitution of the state was framed and the will of the people of Jammu and Kashmir had expressed. And thereafter, this article must be held to have become ineffective. So that the modifications made by the President in exercise of the powers under this article, subsequent to the enforcement of the Constitution of the state, would be without any authority of law. The Constitution of the state came into force on 26 January 56, and therefore the 2 orders, 59 and 64, passed by the President in perpetuate exercise of power under 370 were void. It was also urged that the provisions of Clause 2 of Article 370 support this view. It would also urge that the provision support this view because it directs that if the concurrence of the government of the state is given under Para 2 of Subclause B of Clause 1, or under the second proviso to Subclause D of that clause before the Constituent Assembly for the purpose of framing the Constitution of the state is convened, that concurrence had to be placed before such assembly for such decision as it may take thereon. From this, it was sought to be inferred that the power of the President, depending on the concurrence of the government of the state, must be exercised before the dissolution of the Constituent Assembly of the state, so that the concurrence could be placed for its decision, and that power must be held to cease to exist after the dissolution of the Assembly. Were not impressed with either of these 2 arguments advanced by Ramamurthy. So far as the historical background is concerned, the Attorney General, in appearing on behalf of government, relied on it to urge that the provisions of 370 should be held to be continuing in force. This is important. Continuing in force, because the situation that existed when this article was incorporated in the Constitution had not materially altered. And the purpose of introducing this article was to empower the President to exercise his discretion in applying the Indian Constitution, while that situation remained unchanged. There is considerable force in this submission. The legislative history of this article cannot in these circumstances be of any assistance for holding that the article became ineffective after the Constituent Assembly of the state had framed the Constitution. And then, Mullahs, ultimately, Para 7 is important. There are, however, much stronger reasons for holding that the provisions of this article continued in force and remain effective even after the Constituent Assembly of the state passed the Constitution of the state. The most important provision in this connection, kindly note that, is contained in Clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the state referred to in Clause 2 shall be necessary before the president issues a notification. Well, that's what I was trying to tell my Lord Justice Khanna. Before, this is a constitutional bench judgment. This clause clearly envisages that the article will continue to be operative and cease to be operative only if, on the recommendation of the Constituent Assembly, the President will make a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by the presiding President declaring that the article shall cease to be operative. On the contrary, it appears that the Constituent Assembly of the state made a recommendation that the article should be operative, with one modification to be incorporated in the explanation of clause 1 of this article. This modification in the article was notified by the President to the Ministry of Law, CO 44 dated 15 November 52, and laid down that the 17th November 52, the article was to be operative with substitution of the new explanation for the old explanation as it existed at that time. This makes it clear that the Constituent Assembly of the state did not desire this article should cease to be operative, and in fact expressed its agreement to the continued operation of this article for making a recommendation it should preserve.
That's 1 minute.
Yeah. The next submission made for challenging the validity of the orders of modification made in 59 and 64 was that subclause D of clause 1 of 370, the power that is conferred on the President is for the purpose of applying the provisions of the Constitution to Jammu and Kashmir, and not for the purpose of making amendments in the Constitution as applied to that state. The interpretation sought to be placed was that at the time of applying any provision of the Constitution to the state of Jammu and Kashmir, President is competent to make modifications and exceptions therein. But once any provision of the Constitution has been applied, the power under 370 would not cover any modification in the Constitution as applied. Reliance was thus placed on the nature of the power conferred on the President to urge that the President could not, from time to time, amend any of the provisions of the Constitution as applied to the state of Jammu and Kashmir. It was further urged that the presidential power under 370 should not be interpreted as applying Section 21 of the General Clauses Act, because the constitutional power cannot be equated with the power conferred by the Act. But as the court ultimately relied on 21. The argument, in our opinion, proceeds on an entirely incorrect basis. Under 3671D, the power of the President is expressed by laying down the provisions of the Constitution other than Article 1 of 370, which under 371C became applicable when the Constitution came into force, shall apply in relation to the state of Jammu and Kashmir, subject to the exceptions and modifications that the President may order specified. What the President is required to do is to specify the provisions of the Constitution which are to apply to the state of Jammu and Kashmir. And when making such specification, he is also empowered to specify exceptions and modifications to those provisions. As soon as the President makes such a specification, provisions become applicable to the state with the specified exceptions and modifications. The specification by the President has to be in consultation with the government of the state if those provisions relate to matters in the union list and the concurrent list specified in the instrument of accession, governing the accession of the state to the Dominion of India, as matters with respect to which Dominion legislature will make law. The specification in respect to all other provisions, that is subclause D, clause 1 of 370, has to be with the concurrence of the state government. Any specification made after such consultation or concurrence has the effect that the provisions of the Constitution specified with exceptions and modifications become applicable to the state of Jammu and Kashmir. Cannot be held that the nature of the power contained in this provision is such that Section 21 must be held to be totally inapplicable. So, that's it, Malad, as far as. No, para 14, sorry. It was also urged, para 14, PDF, Malad, 33. It was also urged that the power of making modifications and exceptions in the orders made by Article 371D should at least be limited to making minor alterations, not cover the power to practically abrogate an article of the Constitution applied. That submission is clearly without force. Challenge to the validity of 35C introduced to the Constitution as applied to Jammu Kashmir on this ground was repelled by the court in Dakhanpal. Subsequently, the scope of the powers of making exceptions and modifications was examined. So, as long as the exceptions or modifications are made with consultation or concurrence, depending on the instrument of accession or the concurrent list matters, there's no issue at all. The president could do it. But beyond that, no. Now, therefore, now this is the case that the other side is relying upon, that was C67. This is the important case. That is PDF 36, same volume. Makbul Daman. It's a 32 petition. Again, a detention matter. What's the time? Yes, then I finish. After this, I'll touch it for 5-10 minutes on the Reorganization Act. The rest others will do this. I have done. Well, let's, Mr. Garg, well, this is again a detention matter, who appeared on behalf of the petitioner, raised the following points. Paragraph 6 at page 40. Very inspirational lawyer, Mr. Garg was. Yes. He would be sitting at the back of this court and pretend to be sleeping when he would suddenly wake up. He'd suddenly wake everybody up, including himself. And he'll tell the court that they were wrong and they were right. An amazing personality. And wedded to the cause of at least in matters of preventive detention, and always appearing for the weak and for the marginalized. Always. We owe him a lot. Mr. Garg, who appeared on behalf of the petitioner, raised the following points before us. That the Jammu Kashmir Preventive Detention, herein referred to as the Amending Act, was invalid as it was assented to by the Sadr-e-Riyasat. Not invalid, as was not assented to by the Sadr-e-Riyasat. It was assented to by the governor, but he said the Sadr-e-Riyasat was directly elected. The governor was not directly elected, so therefore this is completely unconstitutional because he did not give his assent to it. That the proviso inserted by 4.2 of Section 8 is bad because it suffers from excessive delegation. There has been no violation of Article 21-22. At any rate, the proviso is bad because it conflicts with Section 103 of the Constitution. The detention order is bad because the detaining authority has not applied its mind, and the order of detention is bad because it is not served or executed in accordance with law. In support of his contention, learned counsel urged that 370 was the only authority which is recognized as the government of the state of Jammu Kashmir is the Sadr-e-Riyasat. 370 contemplates that Sadr-e-Riyasat would be the head of the state of Jammu Kashmir, and Jammu Kashmir Assembly had no power to abolish the office of Sadr-e-Riyasat. He further urged that Section 147 of the Constitution, which I've read to your Lordship, also contemplates that the Sadr-e-Riyasat shall exist and be the head of state. He urged that the only possible way of getting rid of the Sadr-e-Riyasat would be to amend the Constitution of India as applied to Jammu Kashmir. The Attorney General who appeared on behalf of the government, Mr. Chagla, who appeared for the state, contended that the Constitution of Jammu Kashmir, which had received the assent of the Sadr-e-Riyasat, validly amended the Constitution of Jammu Kashmir and validly provided for appointment of a governor in place of Sadr-e-Riyasat, and therefore the governor was competent to give assent to the Jammu Kashmir Preventive Detention. That was the limited issue. That the Sadr-e-Riyasat was directly elected, governor was appointed, the Sadr-e-Riyasat never gave his consent, Therefore, this detention law where the governor gave consent is valid. Then straight away, 13 minutes. Paragraph 13 at PDF 42. On January 26, 1950, the constitutional application of Jammu Kashmir Order 1950 was made by the President. On April 20, 1951, the Maharaja of Jammu Kashmir issued a proclamation in pursuance to which the Constituent Assembly of Jammu Kashmir was convened on November 5, 51. On June 10, 1952, the principals of the Committee of Jammu Kashmir Constituent Assembly submitted an interim report in para 14. The Constituent Assembly by resolution adopted these recommendations. The following part of the resolution is relevant. Now, therefore, in pursuance of the resolution dated 12 June 52, and having considered the report of the drafting committee, this assembly resolved that the head of the state shall be the person recognized by the President of Union on the recommendations of the Legislative Assembly. Later on, Mullah, it was directly appointed. Sorry? Oh, I see. I'm sorry. The head of state shall be the person. He shall hold office during the pleasure of the President. He may, by writing under his hand, address to the President, resign his office. Subject to the foregoing provisions, the head of state shall hold office for a term of 5 years from the date he enters upon his office. And then, Mullahs, provided that he shall, notwithstanding the expiration of his term, continue to hold office until his successor enters, that the recommendation of the Legislative Assembly of the state in respect of recognition of the head of state shall be made by election. Then, Mullahs, November 16, 1952, the explanation was, Mullahs, in a way, it was amended by a recommendation of the Constituent Assembly. Just mark that, Mullahs. In exercise of the powers conferred by this article, the President, on the recommendation of the Constituent Assembly of the state, declared that as from 17th day of November, the said 370 shall be operative, with the modification that for the explanation in clause 1 thereof, the following explanation is substituted. For the purpose of this article, the government of the state means the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as the Sadr-e-Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers. So when this argument was raised, the court ultimately came to the conclusion that in essence, this Sadr-e-Riyasat is a governor. So there is no substantial change. Then let's directly to 19, Mullahs. PDF page 44. I'm trying to, Mullahs, hasten the pace so that. On November 1756, Jammu and Kashmir Constitution was adopted. Some sections came into force on the day of and remaining sections came into force in 57. Then Mullahs, few lines thereafter, on November 24, 65. This is important. The President, in exercise of the powers by clause 1 of Article 370, with the concurrence of the government of Jammu and Kashmir, made the constitution application to Jammu Kashmir's Second Amendment Order 1965 for subclause B of clause 4 of 367. Lordship sees that? The following clauses were inserted. References to the person for the time being in force recognized by the President of the recommendation of Legislative Assembly as the Sadr-e-Riyasat, acting on the advice of the Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the said state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. Then para 21, according to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at that time. What are the constitutional conditions? Well, every state had a governor. He was not directly elected. And Constitution of Jammu and Kashmir itself stood amended in 1965, Mullahs. And the head of the state was to be the governor. So according to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at the time. According to Mr. Garg, this is the kingpin of the whole relationship between the Union of India and the state of Jammu and Kashmir. According to him, neither the Jammu and Kashmir Assembly nor the President were competent to impair the functioning of the Sadr-e-Riyasat insofar as the Constitution of Jammu and Kashmir Sixth Amendment Act 1965 replaced the Sadr-e Riyasat by the governor is his ultra-vires. According to him, either there has to be an amendment to the Constitution of India under 368 and 373, or a fresh Constituent Assembly had to be convened to amend the explanation. He said that if the text of the Constitution is explicit, effect must be given to it, and it is not the duty of the courts to improve upon the Constitution because the Constitution makers had not anticipated it. So, the court rejects that argument, and then, at page 24, this para 24 is the heart of the matter. The Learned Counsel, relying on Sampath Prakash, contended that the only way of modifying 370 is specified in Article 370, sub-Article 3 itself. He said that this was expressly laid down by this court in the decision referred to. We are not concerned with the question whether Article 373 can now be utilized to amend the provisions of 371 or 2, and therefore we do not express any opinion on that point. We are now not concerned with an amendment to Article 370, subclause 1. We are concerned with a situation where the explanation ceased to operate. It has ceased to operate because there is no longer a Sadr-e Riyasat in Jammu and Kashmir. Now, the next is important. If the definition contained in the explanation cannot apply to the words government of the state, then the meaning of Article 367(4) is amended will have to be given to it. It is this meaning, if this meaning is given, it is quite clear that the governor is competent to give the concurrence stipulated in Article 370. And then, Mullah, kindly come straight away to para 29.
Para?
PDF page 47. I had Mullah's your PDF page 47. If we had regarded this as an amendment to Article 370, Clause 1, then we would have had to consider whether the amendatory powers had been validly exercised or not. But as we have said, we're not concerned with that question.
Which para is this?
This is 29.
29.
Yes. So clearly, Damnu is not for a proposition that you can amend 370 in this process by virtue of 367(4). That's what the union has tried to apply. That Damnu has already decided this issue. So, now I am finished with the judgments also. Now I'm left with the last, which I'll finish by 4 o'clock. 15 more minutes.
That's the reorganization.
That's the Reorganization Act. Now, let's go to the, first of all, so Jammu and Kashmir, Constitution of India as applicable to Jammu and Kashmir, Article 3. This is at document volume 2, PDF page, 1, not 2. PDF page 65. Article 3. So I've shown you what's the proviso already in Article 3, that no bill shall be introduced in Parliament without the consent of the legislature of the state. And I've shown to your lordship the August 5, the bill was introduced. Now see the Constitution of India along with this Article 3 of the Constitution. I'll just make a brief argument so that then others can, if they so choose, which they will, I'm sure.
Article 3, right?
Constitution of India, Article 3. Formation of new states and alteration of areas, boundaries, or names of the existing states. Parliament may by law, my lords have that, may by law form a new state by separation of territory from any state. So if you have a large state, you can form a new state by separation of territory of any state, or by uniting two or more states. So you can form a new state by uniting two or more states, or parts of states, or by uniting any territory to a part of any state. That's the way you form states, Mullah. Or you bifurcate states. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Provided that no bill for the purpose shall be introduced to either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred to by the President to the legislature of that state for expressing its views thereon, within such period as may be specified in the reference, or within such period as the President may allow. The period so specified or allowed has expired. Explanation. This is important. In this article, in clause A to E, state includes a union territory, but in the proviso, state does not include a union territory. The power, then explanation 2, the power conferred on Parliament by clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. Normally, if you're going to read in explanation 1, state includes a union territory. Let's go back to the definition now. Let's see how it fits in. So now you say form a new union territory. Let's read the word instead of state as union territory. If you, Mullahs, substitute the word union territory wherever the word state is used, this article will make no sense. And I'll read it in that fashion. Form a new union territory by separation of territory from any union territory.
No, but it could be by separation of territory from any state.
That's correct. So therefore you can't read, therefore only in the first part you will read union territory. That's my submission. In other words, form a union territory by separation of territory from any state. You can do that. Or by uniting two or more states, you can have a union territory. Or parts of states, you can have a union territory. Or by uniting any territory to a part of any state. How can you create a union territory for Jammu and Kashmir under this article? You can't do it. You can carve out a union territory. You can't create a union territory under Article 3 and convert it into a state into a union territory. That's contrary to all principles of representative form of government. It doesn't allow extinguishment of a state completely. Can you say that tomorrow Madhya Pradesh will be a union territory or Bihar will be a union territory? You can do it to one, you can do it to all. You can have a presidential form of government, create all states, convert all states into union territory. By what stretch of imagination can
What about textually?
I'm sorry?
Textually. The other argument is, of course, that you can't do it because you said representative democracy, but textually can you not do it?
No, because I'm saying you form a union territory by separation of a territory from a state. From any state. Or by uniting two or more states or parts of a state. This is not that exercise at all. You have created two union territories from a state. Where is that power? Well, there are multiple categories. What they have done doesn't fall in any of these categories. You can carve out a union territory. If you have two or more states come together, you can carve out a union territory. If a part of a state, you can carve out a union territory. But you can't create two union territories in a state. How is that possible? Apart from what my Lord said, representative form of government, you can't. You're not going back, mothers. Moving away from a representative form of government. This is not a reverse. Yes, 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 that was possible. Whereas you could have kept Ladakh, as a union. I'm sorry.
The report is there on record.
I won't go into it, my colleagues will, which tells you as to how the union thought as to how union territories are to be created. In 1953, way back, there's a State Reorganization Commission. My learned friends will refer to it. I don't want to do that. But essentially, there are two aspects to this. The text of the Constitution doesn't allow you to do that. And the fundamentals of constitutional democracy don't allow you to do that. You can't go back in time, move from representative.
My judgment in NCT 2
Yeah.
traces the history of how you had the Part A, Part B, Part C state.
correct.
How then, after the Seventh Amendment, you
Yes.
replaced the Part B and Part C states, and the union territories were created.
And NCT judgment deals with asymmetric federalism. It's a case of asymmetric federalism. Of course, now they've done something else, so that your lordship will hear now. With another way. Otherwise, Malad, this power can be exercised at any time.
Okay, yeah.
Yes, yes. words, Malad. Where is the voice of the people of Jammu and Kashmir? Where is the voice of representative democracy? 5 years have passed. Have you heard, Malad? Any representative form of government? When you convert a whole state, Malad, this way all of India can be converted. This power is given. And Malad, the proviso said you have to take the consent. You do away with that through an executive act. You don't even take their views. You become the legislature yourself. So where do we stand, Malad? We stand at a situation where, Malad, though the Constitution is a political document, its provisions can't be manipulated and maneuvered for political ends. It cannot be. That's not how you interpret a constitution. It is a political document, but you cannot politically misuse it and maneuver it and manipulate it, which is what has been done. That can't be done. And even when there is a clash of arms, the law is never silent. The law is not concerned with that. The court is never silent. And whenever the court has been silent, the consequences have been disastrous. It's time for your lordships. And what is a constitution? A constitution is a set of values. Values on the basis of which people will represent themselves and their voice will be heard. If you, through such executive acts, silence the voice of the people, what is left of democracy? And all that I can say to your lordships is that this is a historic moment. Historic not for the present, but for the future of India. And I hope this court is not silent. Thank you.
Thank you very much,
Only
Mr.
one-
Subba. Thank you.
Only one
Who
thing.
will follow now?
What was, just my lord, since this occurred, my lord, on the union territory part, the lordship would also examine, my lord, after the court is over.
Yes.
What was read was the provisions of Article 3 as applicable to Jammu and Kashmir then. Thereafter, the entire constitution is applied before the reorganization took
Yes,
place.
yes, that's what
And
we are
therefore,
telling you.
please read as applicable to entire country.
I read
Your
both.
lordship would get the answer.
I read
Was
both,
a
both
little-
applicable as well as the constitution. My direction is wrong. I read both. I was reading the Constitution, Article
The
3.
explanation
Both.
was not written. Really
I
have
mean, what are you saying?
Was a
I don't know. Obviously, you didn't even hear what I said. So therefore, he was silent while I was arguing, Manoj.
I can't interrupt him.
Mr. Zafar Shah will be arguing now.
My Lord, I beg to appear, my Lord, after Mr. Sibal.
All right. Mr. Subramaniam, which area would you be covering broadly?
My Lord, I will be covering some parts of the unfinished, if I may say so, portions of Mr. Sibal. Largely, I wouldn't take very long. Your Lordships may be assured of that. But there are some points, my Lord, which need to be cemented, particularly with reference to the decision of the Constituent Assembly of Jammu and Kashmir itself.
So we begin tomorrow morning. Mr. Subramaniam, can we request you to complete by lunch tomorrow?
I think, my Lord, that's a very fair suggestion.
After that, who will be the next person in line?
So, yes, certainly. Then we will hear, so Mr. Subramaniam will take through to lunch tomorrow, and then you can, how long would you take? Complete by the end of the day tomorrow.
स्टार्ट से पूछ रहे थिंक तो हो गया टेंशन नहीं हुआ और होगा
మైనారిటీ సోదరులకు కూడా మరొక కార్యక్రమం ప్రారంభమైంది, వారికి కూడా ఇవ్వబోతా ఉన్నాం. ఆ తర్వాత గిరిజన సోదరులకు కూడా తప్పకుండా ఏదో దశలో ముఖ్యమంత్రి గారు తప్పకుండా ప్రారంభిస్తారనే విశ్వాసం నాకుంది. అంటే సమాజంలో ఉండే ఏ వర్గాన్ని, ఏ పేద కులాన్ని కానీ, ఏ పేద సమాజంలోని ఏ పేద వర్గాన్ని కూడా